Hey, good Saturday afternoon. Carl Rominger here, 540-0580. 540-0580. Call in with your legal questions now. Looking at the Patriot today, prosecutor weighs test of law on fetal death. Interestingly, there's a lot of debate about whether or not you should be able to charge somebody with the death of a fetus. And the Abortion Control Act here in Pennsylvania actually says that a fetus shall be accorded all the same rights as a person in the civil or the criminal law, which a number of years ago led for me to file for bail for a pregnant woman who was in jail, saying that the fetus's right to be in a safe environment was being abridged by the fact that the government was holding the fetus in jail. Mere fact that the fetus happened to be inside of a woman who was on bail wasn't the issue. And the same prosecutor who's bringing the charges against somebody for fetal death under the Abortion Control Act, of course, opposed that. He was on the opposite end of the case and did his job well. And I tried to take it all the way up to our state Supreme Court, and nobody would give me the time of day. The trial court denied me. The Superior Court denied me without opinion, and the Supreme Court denied me without opinion. But if you read the law, the Abortion Control Act, and you read it for what the legislature said, a fetus has all the same rights as a person in Pennsylvania. And I guess maybe the prosecutor now agrees with me. I don't know. 540-0580. Scott, you're on WHP 580 with Carl Rominger. What's going on?
Hi, I have a question concerning tenants. I have just taken in two tenants about 3 months ago, and the one was in the reserves, in the Army Reserves, and got called up to duty.
Right.
Now, she splits the apartment with her sister. Okay, both names are on the lease, and I understand through the Soldiers and Sailors Deployment Act that she is eligible to get out of her contract of the lease. My question is, with the sister, being both of their names is on the lease, then she's going to have to be responsible.
Yeah, I don't see how it helps the sister.
Pardon me?
I don't see how it helps the sister at all.
No. The sister then becomes, what I'm asking is, if I'm correct on this, the sister then becomes liable for the whole lease, correct?
Well, I guess I'd have to look at your lease, but if they're jointly and severally liable for the amount of the rent, in other words, your lease is written as in a standard form and the correct form, you'd say that each individual is individually responsible for the entire amount of the rent. Yes. So, yeah.
Okay, and then if she can't come up with the lease, then I can evict her. So.
Yeah.
Okay.
And sometimes, I don't know what your communication level with your tenants are, but sometimes this is a good opportunity to go to them and say, listen, realistically, you got to pay the whole rent. So what's your plan? Are you gonna be able to do it? If you're not going to be able to do it, should I let you pay 3/4 of the rent next month, but you promise me you'll have a tenant, you're a new person in by the month after, or do I need to evict you, or what are we doing?
Right. And I am trying to negotiate something like that.
But yeah,
okay,
at the end of the day, each person on a lease, and this just, and Scott, while I got you for a second, let me remind all the people out there, like when your kids go away to school and you sign the lease as the parent, yes, you become personally responsible for it. If you co-sign for a friend on a lease, I've seen this done before, I got bad credit, they won't let me in, but they said if somebody else will sign the lease, you don't even have to live there as long as you promise to pay. But generally speaking, each tenant is individually responsible for the entire amount. And I have a lot of horror stories where, one of the tenants really doesn't care about their credit. This girl at least left for a legitimate reason. Yeah, right.
And I understand under the Soldiers and Sailors Act, there is nothing that I can do to collect the rent from her deployment on out, correct?
That's my understanding of it as well.
Yeah. Okay.
All right, brother.
All right. Very good. Thank you. Bye-bye.
540-0580. Carl Rominger answering your legal questions here. Of course, don't forget we've got offices in Carlisle, Chambersburg, and now Lancaster. Cynthia.
Yes, hi. I own an apartment house in Harrisburg, and I would like to put that in trust for my children.
Okay.
Could you tell me, if that's the case, do I have to have it reappraised and then also pay a 2% transfer fee on that to the state of Pennsylvania?
The short answer is you're going to have to pay a transfer fee, yes, because you're going to be putting it in trust. I mean, I assume you're talking about the kind of trust that the nursing home can't get to and the kind of trust that creditors can't get to.
That's part of it. Yes, I'd
Yeah.
like to make sure that the apartment house goes to my children.
Yeah.
And
So you need what's called an irrevocable trust, which becomes its own taxable entity, and so it is a taxable transfer. At least that's my short line on it, unless somebody wants to correct me on that. But it would seem to me that yes, that would be a taxable transfer, and of course the appraisals for purposes of determining out what the amount of the value you pay tax on is. Although I'm not sure you'd have to use an appraisal, I suspect the county would accept something that's close to the assessed value as well.
All right. Okay, but I do have to pay the 2%, even though it stays within my family. I still.
Well,
have
it's
to
not
pay
in your
that.
family anymore. It belongs to an irrevocable trust for which your kids are the beneficiaries.
They're the beneficiary. Can I be the trustee of my own irrevocable trust?
You can,
Okay.
but but your control still is very limited, and your access to the asset at the end of the day is still very limited.
So who would have control and access then? My children?
Well, no. What I mean by that is if the asset has to be tied up in the trust in a way that you can't get it anymore. You can get income on the trust.
Uh-huh.
But you're not going to be able to reach the corpus of the trust, or else your creditors will, and there's no purpose of setting up the trust that way.
Okay, so it has to be an irrevocable trust then.
Yep.
Okay, you answered my question, and I thank you very much.
All right, Cynthia. I think Russell. There's a guy named Russell that's going to jump on here as a comment on my answer here. So why don't you hold on and listen on the radio here, okay?
Thank you.
Russell,
How are you?
What am I saying wrong? Tell me.
Well, the one thing that she asked as to whether or not she's subject to the 2% transfer if she transfers that into her children's name. As long as they can show blood relation, it's exempt from transfer tax in the state of Pennsylvania if it's true real estate.
But she didn't say about transferring it to her children. She wants to transfer it into an irrevocable trust for which her children are the beneficiaries.
Right, but as far as it goes, as long as the truth of the matter, it should still be considered an interfamily transfer. That one's a hair splitter, but it's always been my understanding that as long as the beneficiaries of the trust are blood family members,
okay, then we can still exempt.
Daughter, son, the daughter, anything of that ilk, that she should still be able to be exempt from the transfer tax.
All right, brother. Thanks for the help.
All right, you're welcome. Take care.
All right. 540-0580. Gina, you're on WHP 580.
Did you say Gina?
I did.
Oh, sorry, I didn't hear it. A quick question. If a child has turned 18, but they're still in school, not college, high school, is the parent responsible for any trouble they may get into for fines or anything?
Well, the short answer is if they're emancipated. So they're in college now, they're over the age of 18, right?
No. If they'd still be in high school at 18.
Oh, yeah. I mean, the short answer, you still have a duty of support to a child. I'm not certain about on the criminal side, though. I don't know what the juvenile law does. I don't think the juvenile law reaches a parent at that point.
Okay.
But
so criminal possibly.
I mean, what I'm saying is that the child's going to be responsible criminally for their own acts. That's clear at that age.
Okay.
On the other hand, I don't think that the parent can be reached, but I don't know what the cutoff is on that. And I know that when the child's under 18, there's a certain amount of parental liability.
Right.
When the child's over 18 but still in high school, they're not considered emancipated for your duty of support to the child. But I don't know if that means they can reach you criminally, in other words, with a juvenile-style fine or not.
Okay.
This is the kind of thing I'd have to take a look at. If you want to post it on weekendappointment.com, Shane will make sure one of the guys in the office looks up the answer for you.
Okay. Thank you very much.
All right?
Okay, bye.
540-0580, Carl Rominger here answering your legal questions on Weekend Appointment. I'm going to go to break here. I want to get back from the break. I'm going to keep taking your calls. See you in a minute. Hey, welcome back. Carl Rominger here answering your legal questions here on WHP 580. Whatever you want to know about, just call in. We'll try to answer it. As you saw, I did get a little assist earlier there. Of course, I need to know the answer to that. The question had to do with trust, an irrevocable trust, and whether or not you would have to pay the transfer tax. And the short answer is yes, although somebody's telling me that if the true beneficiaries of the irrevocable trust are all blood relatives, you may still be able to exempt it. I think that's something that I'm going to have to find out about. That's one of those ones where I'm not sure which way it goes, although I don't have any reason to doubt the caller, because that would make sense if they're the true beneficiary. The problem is the true beneficiary may not matter if it's an irrevocable trust because it's an independent taxable entity. So I need to find the rule for the workaround on that. See, that's what we lawyers sit around and do. Steve, you're on WHP 580. What's your question?
Good to talk to you.
Hey, good to have you.
Hey, quick question for you. I heard you on with Durgan a couple weeks ago talking about police interrogations.
Yeah.
It's legal for a cop to lie to me if
Mm-hmm.
I'm being interrogated. Is it legal if you're my attorney for a cop to lie to you?
That's an interesting question. The short answer is I don't know why not. I don't know there's no law against it. And what do I mean by that? Lying in and of itself is not illegal, right?
Mm-hmm.
And a false swearing to a court is obviously perjury, but a false statement to a law enforcement official is in and of itself a crime. As an attorney, private defense attorney, or even as a public defender, I don't think we fit in the category of law enforcement agent, although we might argue we do, because we try to enforce things like, pesky laws like the Constitution. Nonetheless, I could see the police officer saying, hey, I lied to the attorney, who cares? I can also see a judge taking a dim view of it and maybe giving you some relief, but I'm not sure it's going to carry the day. The flip side is, and here's what I always explain to clients, when I meet with a police officer and he tells me he's going to do A, B, or C, if he lies to me, what he risks is two things. Number one is I may have enough juice or credibility that when I go to his boss and say he lied to me, he might get in trouble on my word alone. But let's assume for a minute that they don't care about that and they don't think that's going to matter, and maybe I don't have that enough credibility with that particular department. I can tell every other lawyer out there, however, and every other prospective client in the future that this cop lies and told us something that turned out not to be true. Therefore, we're not going to strike any deals with him. We're not going to help him out or exchange any information with any kind of quid pro quo type promise. And I'm going to make sure that every other defense attorney in a 100-mile radius knows, don't trust Officer so-and-so because here's what he told me and here's what he did. And it only handicaps themselves. So I can see a good reason not to do it, which is that it breaks down the trust that you have to have. I can think of a time that, and I know I'm talking away here, but I can think of a time when my phone rang one evening. I'm out for wings with the boys, and it's a woman on the phone who's an attorney for the Attorney General's office, and she's like, hey, I'm here with a client of yours. Put him on the phone. I talked to him for a minute, and get back on the phone, and I say to her, have you got him good? And she's like, oh, yeah, I got him real good. I said, no, there's no issues here. I'm not going to read the search warrant later and go, this was spotty, or there was any problems with any of the issues, any of the things that I would want to raise as a defense attorney. She's like, no, I've got him nailed down solid. I'm like, all right. And I put him back on the phone. All right, you cooperate. And the answer is I know her and I trust her. And if she tells me that there's no issues with the case, I know later there's not going to be an issue with the case. Does it make sense?
Yeah, it does.
But on the other hand, some other attorneys, I would have told the client, like, I don't know what to tell you right now because I don't necessarily trust this prosecutor as well as some others. So, to completely steer me in the right direction.
Yeah, that's amazing. Hey, other quick question.
Yeah, go ahead.
If I don't currently have any business relationship with a lawyer, and I was in an emergency where I thought I needed one,
good luck.
Yeah, is it really?
Here's the answer. And this is what I tell people. Two problems arise. Number one is it's tough to get hold of a lawyer at night.
Mm-hmm.
I mean, if you have my cell, you might get me, you might not. I might be 3 sheets to the wind at the Blondies. I mean, you never know. Worst case scenario, though, is if you're actually arrested, you're going to find that your access to a lawyer is very diminished. You say, I want a lawyer, and the police look at you and go, great. And then they just sit you down, and they have 6 hours to bring you to a judge, and they don't have to get you a lawyer. They just have to allow you to get in contact with your lawyer. So, basically, by the time, if you're arrested at 10 o'clock at night, by the time the police are going to be done processing you with the judge and dump you off at the prison, your lawyer's going to be up and available anyhow. So the short answer, I always tell people, just don't say anything. There's nothing you can say that's going to benefit you. And conversely, like I was telling you, that prosecutor knew my number to call me. There's a few other police officers that have called me before. I have my cell number. And a client says to them, hey, I want my lawyer. Who's your lawyer? Oh, it's Carl Rominger. Oh, I have Carl's cell right here. We'll see if we can get him on the phone. Of course, they rarely ever get me because they're calling me at like 4:40 in the morning. But I get the message in the morning. I know who to call and, say, hey, Tammy, check the prison, see who's out there. But all seriousness, yeah, you can put one of us on call. It's just that getting a lawyer literally in the middle of the fray is very difficult for two reasons, which is we're hard to get a hold of at night, which everybody is, unless they're literally in their office. And the more practical reason is the government isn't going to let you. So, like when they're executing a search warrant on your house and you ask for your attorney, they just sit you on the sofa, keep you in cuffs, and 3 hours later, when they're done searching, they might let you call your attorney.
Okay.
So So the practical answer is there's very little benefit to it, but if you're an established client, I'm always happy to give out my cell number on the off chance we're able to. And I have been out to the police barracks at midnight before. I've been in night court in Dauphin County at 2 a.m. So it happens.
Okay. Well, great. Thanks a lot, Carl.
All right, Steve. Oh, by the way, I will be filling in for Durgan on Monday too.
Oh, great. I'll listen for it.
All right. Take care.
All right. Yep. Bye.
Let's see. I got 2 Bills. Bill.
Yeah.
What's going on?
Hey, I got a good one for you. A couple months ago, I was coming home from a doctor's appointment. It was 9 o'clock in the morning, and I was coming into town, and I thought I saw a dog, so I swerved, and I ended up hitting a basketball hoop. Airbag went off, these things. Police came. I had just left McDonald's, too, on the way home, but the police officer came and asked me if I was drinking or anything. I said no. And he said, well, what happened? And I said, I think I saw a dog. And he said, well, I'm going to take you and go get you tested. And I said, all right, that's fine. So he never read me my rights or anything, but handcuffed me, put me in the car, took me, to the hospital. I got a blood test, was fingerprinted. And I said, am I going to get any fines out of this? And he said, no, not yet. I don't think so. So to make a long story short, the test came back that I didn't have anything to drink. And he showed up at my house then. And he said, well, I guess you're okay. And he just let me go. But it was like, is that the proper procedure?
Well, here's the answer. The long answer is yes. The short answer is, why is he taking you down to the hospital? I mean, he didn't smell like booze, right?
Right. Yeah, there was actually a nurse there, too. I had my soda from McDonald's, and she took the cup from me, I guess thinking it might have been something in it. And she smelled it, and she said no, and she gave it to him, and he just dumped it out. Looked at my car, didn't find anything. Like I said, it was 9 o'clock in the morning, but it was just like, here I was. I actually ended up having 3 broken ribs, and my eye was swelled shut. I don't even actually remember what the heck happened, to be honest with you. But
well, maybe you were maybe you were a little, maybe you seemed intoxicated to him. But the short answer is the mere happening of an accident is not the basis for the police to test you for intoxication. They've got to have some other indicia of intoxication beyond that. So theoretically, he violated your constitutional rights by arresting you without probable cause to do so, to take you to the station or the hospital and have you tested.
It took up like a whole day and things. Meanwhile, I was just like, geez, I just felt totally violated after the whole thing.
Yeah. How long ago did this happen?
This just happened like a couple months ago.
Well, you got 6 months to put him on notice that you want to sue him for violating your constitutional rights.
Is that worth something pursuing, though?
The guy you'd want to talk to is Vinny Manfredo in my office. He does the 1983 actions. Mm-hmm. The short answer is they're interesting cases because you can get punitive damages.
Well, the thing was, it kind of traumatized me. I'm 47. I never had an accident my whole life. Right. I never got a fine. I never got in trouble with the law. And just trying to be an honest citizen, and I just totally just didn't think it was correct.
I'm just trying to figure out where the officer got to the stage of arresting you to test you for DUI just because there was an accident. And there's going to be somebody out there going, well, there's an accident. That's probable cause to believe he was drinking because drinking leads to accidents. Most accidents don't involve alcohol, just so everybody out there knows. Most accidents are not caused by alcohol. Most accidents are caused because we're human and we miss the stop sign, we fall asleep, or we swerve to avoid a deer or a squirrel or a dog.
Yeah. Well, okay, so maybe give Vinny a call.
Yeah, Vinny be able to tell you. I'd be curious. Your damages might be nominal, but the court allows for the award of attorney's fees, so sometimes the lawyers aren't afraid to pursue them, if that makes sense.
Yeah, I do. That makes sense to me.
All right, brother.
All right, Carl. Thanks, brother.
All right.
All right, bye.
540-0580, Bill number 2. What's going on? Hey, Bill.
Bill.
Yeah, this Bill.
Yeah, this is me. All right. What about if somebody just flat out refuses to obey a child custody order?
Well, if they flat out refuse to obey it, they can be held in contempt of court and jailed.
Yeah, well, who does that? Because nobody will enforce it.
The only person who can enforce it is the party who's being aggrieved by it, meaning if you're the side that is having it disobeyed, you go to court, you ask the judge for a hearing. We have what's called a contempt hearing, and then the judge makes findings of fact. And if the person's in contempt, he then fines them appropriately and or gives them conditions of purge, etc. and enforces the order. But it's the party who's aggrieved who has to enforce a private custody order like that. The police generally won't get involved.
All right, now, do grandparents have any rights at all?
Grandparents have rights in Pennsylvania, yes. There's a brand new custody law that takes effect on January 22nd, okay, which is coming up here. I haven't completely studied how it affects grandparents' rights and standing, but I can tell you that any case that's filed before it, grandparents have an absolute right if one of the parents is unfit or unable, and grandparents have a right to visitation if the child has lived with them for a period of time, which is usually a year.
Mm-hmm.
But other than that,
Okay.
if your kids are fighting it out and over the grandchildren and you're a grandparent, it's very tough to assert yourself if there's two intact parents there who don't want you involved.
All right, now, what do you charge for consultation on that?
Generally, in my office, it's free consultation. So if you're willing to make the trip over and come see us, we'll meet with you for 20 minutes, half an hour, go over the facts of the case with you for free, and then quote it for you.
Okay.
Can't beat that.
You have a Lancaster office now, right?
We do. We're usually staffing it as needed. So when you make the appointment, just make sure the girls know, or Mike for that matter, the guy too who answers the phone. Shane's laughing at me. Make sure that they know you want the Lancaster office, and make sure that there's no miscommunication. I've had a few people, before go, well, I'm on Hanover Street, and I'm like, well, which Hanover Street, which town?
Yeah. Okay, well, I'll call your office in.
All right.
Thank you.
Thank you. Oh, hung up too soon. I always do that. 540-058. I got to go to break before Shane breaks the glass over here. Hey, welcome back. Carl Rominger here answering your legal questions. 540-0580. Smells like Teen Spirit in here, doesn't it? Oh, filling in for Bob Durgan on Monday. So if you need to get a few legal questions answered, you weren't able to call today or couldn't get through, or Shane bobbled your call and knocked you off the line, just call on Monday. I'll be here 3 to 6 filling in for Bob. Some kind of holiday on Monday, I guess. Never really a holiday when you have your own business, best I can tell. But I guess that's why my staff looks at me sometimes. And I was one, come on, get that guy in here. He can come in on Sunday at 2. And my staff's looking at me, and one of the girls is like, it's Easter, Carl. I'm like, there's a holiday this weekend. And I guess there's probably going to be some kind of Super Bowl people want to take off for too, huh? Can't believe this stuff. Steve, what's going on?
Hi. According to a Patriot News story on Thursday, last Monday, Bob Durgan was discussing the Arizona shootings, and he was complaining about the New York Times coverage of that shooting, and he was encouraging his listeners either to go to New York and burn down the New York Times or blow it up. Now, is that illegal and prosecutable?
Wait, I didn't hear about that.
I heard it myself. It's in the Patriot News. Haven't you read the story?
Was that his comment along the lines of somebody ought to burn that paper down or something along those lines?
To burn it down or blow it up. Now, is that illegal, Carl? WHP has a large listenership, and it covers a lot of territory here in central Pennsylvania. And you're a lawyer. Is it illegal for someone to encourage his listeners over a large radio station to blow up the New York Times?
Well, it's interesting, right?
Yeah, it is interesting. It's not a very nice thing to do either.
Well, listen, I'm not. Maybe on Monday we'll take that up because that'll be a good topic for Monday's show. But here's
what is your opinion?
Wait, stop, Steve. I'm trying to talk. Give me a second. I got to catch my breath. Steve, slow down. What I was going to say is ORATA, errata, or speaking. I'm just trying to think. There's something called dictum, which is just words, and then there's calls to action. And I'm trying to remember the two Latin phrases. But anyhow, it's been said that the more potent one is not the call to anarchy or the call to do something. It's just words that don't call for any particular action, more like what Glenn Beck does every day. So long and short of it is, should he have said that? Listen, I don't think he really literally meant you should do that. So the short answer is it's his subjective intent that controls. And if you tell somebody, somebody should kill that guy, does that mean you're guilty of soliciting murder? I don't think so, unless, you're sitting at the bar and you're talking very quietly and there's other indicia that your true intent is that somebody be killed. Is it polite society? Is it civil society? It probably crosses that line. But I don't think it's a literal call to action. Now, because Steve hung up on me. So I guess I didn't get the answer he wanted. Or maybe his cell phone just ran out of his batteries. I don't know. Anyhow, I'm going to defend Bob on that one just to say, yeah, probably shouldn't have said it that exact way. But I think he meant it the same way, like, we're going to kill them. Hey, the Ravens are going to kill, who's it, Pittsburgh? Or the Pittsburgh's going to kill the bird. I mean, do they really mean that the quarterback's going to rip the head off of the defensive players, or that the offensive line should really, tear the rib cage off of somebody? Do people really mean that when they say it in the bar fight, or when they're yelling about their teams? And the short answer is, did Bob Durgan really mean, somebody get a thermonuclear weapon and blow up the New York Times? I think he was just expressing the frustration that such a prominent newspaper seems to have such a one-sided view of the world. And I can tell you, I don't have the time to do this anymore, but back many years ago when I had nothing to do besides take classes when I was in college, I had the opportunity to read the New York Times and the Wall Street Journal every day. And if you read the two side by side every day and look at the coverage and follow, you'll see two things. One is they do both have particular bents, each kind of predictably going in a different direction. And number two is they sure like to shoot back and forth at each other. So to say that the New York Times is a little biased is probably not incorrect. Don, you're on WHP 580 with Carl Rominger. What's going on? Don.
Yeah. Oh, yes.
Yep. He must have got excited and hung up. Oh, we're losing him left and right here. Bob.
Yes.
Yeah, what's going on?
I have a profit sharing problem here. I work for a company, and I was just wondering, they told me it was 5 years to get this out of there, and I'm having financial problems right now. What I'm trying to do is getting that money out, and they said you got to wait 5 years. I'm just wondering if there's any legal action I could take to get that money out with my daughter in college and all.
Where is the money in, like a 401k?
It's a profit sharing. Wachovia. It says here.
Well, the short answer is we need to see the charter for the plan, and the book basically on it to see what you agreed to at the time you entered into it.
I really didn't agree to anything.
Well, but I mean, you took the money, right? They were putting it in an account somewhere. And my point is, your employer may have done it, but the condition of your employment was there was a profit-sharing plan, so we'd have to see how it was chartered out and how it worked. My advice to you is get the paperwork together and give my office a call. One of the guys can certainly take a look at it for you.
Okay, and
that's the best I can do, Bob, without more information. I'm sure you don't have the book in front of you.
No, I don't have the book. All I have is the statement is what I have.
Yeah, we need to see how it was chartered. All right, brother.
All right, man. Thanks,
all right.
Carl.
Bye. Let's see here. Carol, you're on WHP 580 with Carl Rominger. What's going on?
Who?
Carol.
Oh, that would be me. Hi, Carl.
Hey, how are you?
Hey, I'm fine. How was that heart?
Well, there's 3 of them in there, so I'm not done with them yet.
I know. Hey, I have a quick question. Oh, and by the way, I heard the Bob Durgan comment, and had Bob to do it over again, I'm sure he wouldn't say what he said, and I think it was off the cuff and not meant. I think we have someone. I don't think Steve probably likes Bob Durgan. That said, my call. Does a registered gun that is passed down from father to son need to be re-registered?
I don't think so. I'm just trying to remember this. Well, let me put it this way. I think if there's a literal, like, if dad's handing it to Junior for him to take and keep, I think they might have to go do some paperwork on the handgun to transfer it. But I think there is a provision in the transfer law, without pulling it up in front of me, that talks about the ability to transfer a gun down through the family lawfully.
When you say transfer down to keep,
right?
Are you literally meaning to keep as
yes.
as forever and ever?
Yes, because there's some provision in there that has to do with basically like dad dies and mom just keeps his guns. She's not committed a crime at that point. She hasn't failed to do something. There's a provision in there. But if the mom wants to then sell them, she's got to go through the state police. And I believe the same with the child. The lineal descendant can take them as well if that's who gets them.
But if dad is still alive?
Then I think they should do a transfer.
Okay. All right.
But you know what? If you post that on weekendappointment.com, I will make sure that Shane will help me out here. We'll get somebody to answer it, look it up, so we know for absolute certain.
Okay, super. Appreciate it.
All right, you take care.
Thanks. Bye.
Sometimes I like to check this stuff out. And listen, it just drives me nutty because I know somebody out there's like, well, come on, Carl, you don't know the answer? The answer is I looked that statute up one other time for somebody, maybe even for Durgan a while back, and I have a foggy recollection that there's some ability to do interfamily transfers upon death without paperwork. But as for an inter vivos, meaning during life transfer, I don't know if there's any wiggle room there or not. And so to be certain, we'd like to look it up. And then, of course, for the last 15 years, I've been studying the Pennsylvania custody law in and out, and I know it, pretty much like the back of my hand, except as of January 22nd, there's a whole new custody statute coming out. So maybe we should talk about that on Monday, too, maybe next week. So if you've lost in the custody arena in the past, the laws are changing. If you haven't made a move in the past, you aren't sure, the laws are a little more neutral now. They're supposed to be more gender neutral. They did not add any presumptions, what they talked about doing, which would be a presumption of 50-50 custody. The legislature wussed out on that. But they did revise it, and there's some positive changes in it. There's a lot more work involved in it now for the parties and the lawyers, and they may have practically increased the expense of custody cases in some regards. I'm hoping that the counties would adopt a more uniform system, and the statute seems to suggest that would be a good idea. So as I learn more about the new law, I'll be getting on Facebook with it. I'm going to be sending it as updates on weekendappointment.com. So make sure if you haven't registered for weekendappointment.com and claimed your free will, you at least go register so you can get the updates on the new custody law as we start feeding those out. And I'm going to go to break, and when I get back, I'm going to take Dawn and Tim. Answering your legal questions here on WHP 580. I'm Carl Rominger, 540-0580. Want to remind you, go to weekendappointment.com, claim your free will. I just did one of those yesterday for somebody. We have people in all the time to get their free wills, and it's an honor to do them for you, and it doesn't cost anything. If you just want us to look over your current will, make sure it works. And, of course, we go over a little other information just to make sure you understand all the different things you need to do as you do your estate plan. And no death panels, though. We don't have any death panels in the office, but we do talk about the legal end of planning your estate and your succession and all those good things. Let's see here. Who's up next? Dawn, you're on WHP 580. What's going on?
Hi. My wife and I are owners of a mobile home located in a mobile home park.
Okay.
And just yesterday afternoon, they dropped on us a new lease. They want us to sign a new lease. And it says this document contains information that I need, and to make sure I'm supposed to read the thing and make sure I understand the entire document. Seek legal advice if you have any questions.
Right.
So at the bottom, it says you have 5 calendar days from the date you receive this documentation to cancel your agreement in writing to the manufactured home community owner or operator, and This is in reference to they say that it's in reference to the new Act 80 that was passed October 19th of this past year. Changes to Act 261, the Manufactured Home Rights Act, and there's a bunch of changes in here, and it's going to cost me more money. They reduced the rent, but it's in the end it's going to cost me more money. But anyway, in my old lease, it says either party here to may terminate this lease at the end of any month by giving the other party written notice hereof at least 30 days prior to the end of such month.
Right.
So, my question is, well, then they want me to make an appointment between Monday, well, starting next Monday through the following Monday. And they have hours 7:30 to 7:30, for 5 days and all that. But they want me to make an appointment. I don't have time to see a lawyer to look over this paperwork. And my old contract says they have to give me at least 30 days.
Right. The short answer is the legislature. It doesn't. I believe it doesn't take effect until March. The new law. However, it includes mandatory leases for all manufactured housing and trailer park residents. It slows down rent increases, all kinds of disclosures, and basically they're putting in there an attorney's advice clause, which says you've either met with an attorney and got the advice to go over the agreement with you, or you waive your right to do so.
This doesn't have that.
Doesn't say that. Just says
make sure you read the entire document and seek legal advice if you have any questions regarding the information.
Okay. So what they're telling, that's just a notice that if you want, if you don't understand it, if you got 5 days.
Yeah, 5 calendar days from the date I received it. Well, yesterday, 5 calendar days would be Wednesday.
And, what I would do is write them back a letter that says, I don't understand everything and I can't get into a lawyer within 5 days.
Yeah,
but if you understand everything, it doesn't really matter.
And they give us a whole list of things to fill out, and don't call and ask about it until you get your appointment, until you make your appointment,
Right.
till you have your appointment. I kind of get the feeling I'm getting the bum's rush here.
Well, I have a feeling that nobody knows what to do here. You have to understand, this is just like I was telling you, the Custody Act just changed. This Act 261, basically, the first time in like over 30 years that there's been a significant change to Act 80 or whatever it is. So nobody, and the final format of the thing and how it's all going to look, I guess, has to be sorted out. So they're probably feeling the same stress you are in the sense of they've got to get these.
They said they spent the last 2 months trying to get this thing
figured out.
And that's fine. I understand that, but I should have at least 30 days.
Yeah, and what my advice would be, I don't know what they could say to you if you went back to them and said, I want more time to look this over. And what are they going to say to you?
Nothing. It says we are available the following scheduled appointments, and then they give a list of 7 or 8 days here.
Yeah, listen, nobody's gonna. That's just my experience, anyhow. Nobody's realistically going to evict you or give you a hard time if you legitimately go to them and say, "I need a little more time to figure this out."
Yeah.
Now, the answer is you don't need 30 days. You need however many days it is for you to read it over and get in to see a lawyer.
Right.
If you have questions. But the short answer is I doubt things are really changing too much, so much as this new document is just going to try to conform with the new act.
Well, they made some changes. They were picking up some costs, and now they're putting those costs on us and reducing our rent $15.
Yeah, imagine that. Which, by the way, you know why they're doing that, right? Because every time these do-gooders in the legislature or wherever pass some kind of crazy law to help you out, for instance, now you can only increase rent every 12 months, right?
Yeah.
So if you can only increase rent in any 12-month period, or you got to wait 12 months before you can, it pays to get things out of the rent, right?
Yeah.
So you pass on more direct costs to the consumer. So these are the unintended consequences of being a do-gooder. In other words, you actually probably just incurred more cost than you would have because the landlord's smart and goes, if I keep picking up the water bill, the trash bill, and these other things and rolling it into rent, and one of them goes up suddenly, I'm only going to be able to raise the rent one time, and if I don't raise it enough, I'm the one that eats all the money. But if I sort these out and remove them from the rent, then the tenants will have to take the big swings on these.
Yeah. they have a list of frequently asked questions that I should consider, and one of them says, "How much will this new law cost me?" And their answer is nothing.
Well, the short answer is, in the short run. Maybe in the long run, I don't know. But the point is, all laws warp the business relationship, and this is just another great example of it. And I haven't had a great chance to interpret this. The guy in my office who you might want to sit down and talk to is Eric David. He's our guy that would probably be the most on the ball with this.
Okay.
All right, Don?
I'll give you a call then. That's 800-734-3182?
I don't know. Does that sound like our number? I don't know. Go to weekendappointment.com to get it.
Okay.
All right?
All right, thank you.
That doesn't sound right to me. Tim, you're on WHP.
Thanks, Carl. About 2 years ago, some services were provided. Complication happened. And 6 years down the road, I get a letter about it saying that they want it fixed.
Okay.
Now, the party went to another provider to get services in between the 6 years. And my question is, in order to provide some goodwill back on this, I forget the name of it's some kind of a release because, you don't want to get sued for anything.
Right.
Moving forward, and how enforceable is it, and is it worth it to do it?
What kind of services are we providing?
Medical.
Okay. And repeat your question for me so I understand exactly.
All right. So services were provided 6 years ago.
Okay.
A complication happened.
Right.
Party was informed, and all necessary corrections were made to.
So it's been more than 2 years since the harm happened.
Yes, 6. It's been 6.
So it's outside the statute of limitations.
Yes.
Okay.
So if you just, I think I have the option to do nothing about it, or provide some goodwill about it. But the thing is I don't want it to come back and bite me in case.
Yeah, the short answer is if you go back and provide some goodwill, you might be, re-engaging and renewing the statute of limitations. You need to sit down and talk with one of us off the radio and get some more detail on this, Tim.
Okay.
Guys, I can't answer all the questions on the air without enough detail. Sometimes that's the way it is. Go to weekendappointment.com. Don't forget we got offices in Lancaster, Carlisle, Chambersburg, and we can handle your cases in Harrisburg, Lebanon, and all the rest of central Pennsylvania. And always happy to help you, whatever you need. See you next week.